significance of copyright and intellectual property on publishing. This session is being chaired by Professor Dr. Unnat P. Pandit, Controller General of Patents, Designs and Trademarks. He is also a Professor of IP, Innovation and Entrepreneurship at JNU, formerly Dean JNU, also Program Director, Atal Innovation Mission, Niti Aayog, and also member of IP Think Tank. He's also heading the IP Pharma India and also holds an MSc, PhD, BCIP, LLB, PG, DPL, as well as Executive GMP from IIML. So a very warm welcome to him. He's joining us virtually. And the moderator for this session would be Gauri Kumar. She's the India and South Asia Representative, International Trademark Association. The prestigious International Trademark Association, she represents that with an unwavering passion for intellectual property and trademark and has an industry experience of 18 years. She plays a pivotal role in advocating for effective IP laws and policies across the South Asian region. So a very warm welcome to you. Our esteemed panelists are as follows. Dr. Yogesh Pai, Associate Professor Law, National Law University, Delhi. May I request him to please join us on stage? A very warm welcome to the esteemed panelist. He's an Associate Professor Law at the National Law University and is currently Co-Director of the Center for Innovation, Intellectual Property and Competition at National Law University of Delhi. He's also in charge of the SPRIHA PR Chair at the NLU, which was established by the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry. A very warm welcome to you. We also warmly welcome in our midst Ms. Harini Niveda, Legal Counsel and Group IP Lead, Aditya Birla Group. She is the IP Counsel with Aditya Birla Group and is a qualified patent agent as well as specializing in full spectrum of IP matters, including enforcement, IP transaction, and prosecution, including patents, trademarks, copyrights, and designs at a group level, which covers various industries. A very warm welcome to you. So now I hand it over to the session moderator. It's over to you, ma'am.
Thank you so much.
There is some delay in Dr. Pandit to join us. Meanwhile, I have the pleasure of requesting Dr. Ashok Gupta to please join us on stage and kindly give the opening remarks for this session.
Very good afternoon, fellow publishers and friends. All of us, being publishers, already know about copyright law and its importance for the publishing industry. And if I say that without it, most probably the industry will not survive or practically cease to exist. At the same time, we know that a lot of photocopying and scanning is going on all over India with impunity and without any permission from the stakeholders or from the rights holders. This is going on, and for which we are not able to do anything. Even at the government level, not much response has been coming. At the same time, I think most of you may not be knowing about Indian Reprographic Rights Organization. This organization, how it is connected with publishing, I would try to give you some background, how it is connected, what is it, and what it does. With the new technologies, what is happening is most of the users of the published works do not realize when they do photocopying, whether they are doing few pages or the complete book, that they are depriving the rights owners of their rightful dues. In simple words, it is a theft like any other theft. Also, for the publishers, individual publishers, it is not an easy task to keep track of all the users who are doing photocopies. It is very difficult at an individual level. To bring this illegal activity under control as well as to bring it in a legal way. A section is there in the copyright law about collective societies. IRRO, this Indian Reprographic Rights Organization, is one such society approved under the copyright law. And this was made by Federation of Indian Publishers and Authors Guild of India. This collective administration of copyright is a concept where management and protection of copyright in works are undertaken by a society of the stakeholders, that is publishers and authors. The Copyright Society, because of its organizational facilities and collective strength, is able to keep a better vigil over the reproduction made of published works throughout India, throughout any country, and collect due royalties from the users of those works. It also has under the copyright provisions to issue licenses in respect of its members' works in which copyright subsists or in respect of any other right given by the Copyright Act. These collective copyright societies are also able to have reciprocal agreements with similar societies in other countries for collecting royalties for the uses of Indian books in those countries. Thus, it is in the interest of copyright owners to join these collective administration organizations to ensure better protection of their works, as well as for reaping optimum economic benefits from their creations. On the other hand, different users of different types of works also find it easy to take licenses from one single organization. Any publisher, author, visual creator of books, journal, magazine can become its member. So IRO licenses permit not only the rights of copying of Indian books, also of publications which are available of foreign books in India. Since under reciprocal rights, this arrangement is there, and IRO has already signed about bilateral agreement with 22 countries. And we have been also collecting royalties from abroad, and we have, in last few years, we have distributed about 87 lakhs rupees amongst copyright owners on this behalf. In India, no doubt we are facing tough problems in collecting our royalties, and we are submitting our representations to the government, and some of our representations have also been accepted by the Parliament Committee for certain amendments in the copyright law, and we hope in near future there would be some amendments in favor of our industry. By supporting publishers and authors for over 2 decades now, IRRO has been at the forefront of controlling and reducing unethical practice in the literary sector and continues effort to create a better, transparent, ethical, and equitable world for publishers, authors. In the end, I would just like to say that those of you who are not our members, I would like you to become members of IRRO as early as possible. We may not be able to give you royalty in near future, but this will increase our repertoire and we will be able to push forward our suggestion before the government in a better way. Thank you.
Thank you so much, sir, and thank you for making sure that the audience was appropriately engaged and for that pitch for membership of the IRRO. I hope all of you will consider it because piracy is a very serious crime. It's bleeding the economy and it's depriving right owners of their rightful dues, the creative owners of their rightful dues. So I see that the chair of our session, Professor Dr. Unnat Pandit, has joined. So good afternoon to all the esteemed panelists, to the attendees. This is a very interesting session. We'll not make it very technical because, intellectual property and law, sometimes we sort of, get stuck in the quagmire of legal terms and legal principles. We'll have a very interesting discussion nonetheless that I think all, the publishing industry will completely relate to. India's journey in the world of copyright as well as publishing traces back to the days of colonial rule. And it evolved through that era's emphasis on English education. Today we stand proud as one of the top publishing nations globally, and this is a testimony to our rich heritage and the dynamic progress of our country in the past few decades. Yes, there are challenges. Piracy has deeply impacted the publishing industry, and now with the disruptions brought on by the digital age, the industry stands at a crossroads. So to empower our authors to create, to empower the publishing industry to keep publishing, to empower our country to become an exemplary knowledge economy, I think it's about time that we explored the significance of a robust intellectual property rights framework and how it is pivotal in ensuring that the authors and the creative industry and the publishing industry, they thrive. So there is obviously no better opportunity to have this conversation than today, which is the Golden Jubilee celebration of the Federation of Indian Publishers. I am extremely honored to be the moderator for this panel of brilliant minds and IP visionaries. Joining us today are the Honorable Chair of the session, Professor Dr. Unnat Pandit, the Controller General of Patents, Designs and Trademarks, the Registrar of Copyrights and Geographical Indications, DPIIT, the Ministry of Commerce and Industry. We have Dr. Yogesh Pai, who's the Associate Professor of Law at National Law University, Delhi. And we have Ms. Harini Niveda, Legal Counsel and Group IP Lead at Aditya Birla Group. So welcome everybody. I was going to give all of you a brief bio of all the panelists, but I think I will not do that because our compare and MC so ably and wonderfully has already done that. Thank you so much for that. So let's quickly dive into the questions that we have for this session. And Dr. Pandit, if you can still hear me, my first question, sir, is to you. Yes. How can a strong framework of copyright and intellectual property rights in the publishing industry contribute to fostering a culture of innovation and creativity? And what is the role of copyright laws in nation building and in bolstering India as a knowledge economy? So,
see, I must appreciate that this is something, a forum which has invited a discussion on strengthening the copyright regime and a significant role of copyright and intellectual property, especially on the publishing. So I foresee that there is a need for strengthening further the publication sector and publication industry with the changing intervention of the creative content being utilized in these telemedia and also in the social media as well, and with the changing element of AI driven publications, what kind of reformatory clauses which we want into the Copyright Act, or what kind of amendments which we foresee, not just in the current scenario but the need for fire down the line or maybe later, because the things which is getting protected in copyright having a long term impact, and this is going to foster the culture of innovation and creativity. Copyright publication is one of the important element here, and its role in the nation building has been witnessed even in the pre-independence era. The publication and the secret communications which were happening through the leaflets, through the newspaper, from that era to the current era, wherein the message is getting communicated, utilized in a publish as well as in digital form also. So publishing on print media as well as in digital media has a significance, and that's why we need to have the appropriately the knowledge utilization and protection of the knowledge which is getting expressed in the form of a textual mode, and that kind of a far-sighted vision we should be having. And I would be happy to have the interaction with the group of society where we can have a discussion deliberation on the uh, far-sighted visions provisions in the act also. So I'm open for the suggestions, discussions on this kind of a forward-looking vision. If we are thinking that there is a need, I personally believe that is a strong need now. But as a collective team, we have to work on this. That's what is my submission here. Thank you.
Thank you so much, sir. That was, those were great insights. And I think most of the people in the room, whether they are lawyers or whether they're from the publishing sector, they would agree with you that perhaps the law is in need of change. And it's very heartening to note that, you as the head of the India IP office are open to having these open discussions with various stakeholders. So I will now take the same question to Harini. Harini, it's the same question. What is your take on, the role of a strong framework of copyright and IPRs in the publishing industry?
Thank you for having me here, and I'm very grateful to be on this panel alongside my esteemed co-panelists. See, the entire rationale of an IP right is to incentivize, right? We are giving someone monopoly, or it's actually a negative right. For what? You are incentivizing them to keep creating, to keep innovating. Now, if you don't have it, it's automatically going to have an effect, right? It's as basic as that. Now, when it comes to copyright, be it in content creation, be it anywhere, the copyrights have had a direct effect. An improvement in the copyright laws have also had a significant effect directly in the GDP as well as also in FDIs, right? So having this direct correlation itself speaks for itself as to how strengthening the copyright regime is automatically making a effect on the economy. Now, so I think the importance it speaks to itself. So it's as basic as you're incentivizing people, and if that incentive is not there or it's taken away, I think we are in a way doing disservice to the content creators, to people who are working in that sector, putting whose hard-earned intellectual property it is, to be benefited out of it. So yeah, you need it simply to incentivize, and we've seen studies have shown that there is a direct correlation to the economy and FDIs. So let's work on strengthening it further, and it's so heartening to see Sir as well being open to more, any sort of amendments that may have to come into the copyright law. Today morning also, Smriti ma'am mentioned that it's not that we don't have the law, but we have to, work towards implementation of it, making people aware of the rights. And by doing all of that, we are, strengthening the existing ecosystem further to incentivize members of the industry and at large all of the stakeholders who get affected by copyrights. Right.
Thank you so much, and thanks so much, Harini, for bringing that industry perspective and the very important aspect of FDI inflow as well into the country, which is obviously a very big priority of the current government. And the same question now to you, Yogesh. What is your take? I think our answers are going to be very similar, and therefore it might
Perhaps
be challenging.
not.
But okay. Okay, good
I'm
to
an
know.
academic,
Please.
right? So I like to think a little differently and be a little more argumentative. And I would rather argue that the system of copyright as it has evolved in India historically, has had several layers of turnarounds. Okay, particularly in the 70s when it took a little bit of socialist turn, or under Justice Chagla, then the educational minister, where certain provisions were articulated, particularly in the context of the Berne Convention, etc., and how India later amended its own law. But the idea that copyright is a very strict private property right is actually not very true. Okay, copyright is actually a very leaky right, and that's the reason you have a lot of fair dealing provisions in the law that provides certain kinds of exceptions to those rights Unlike in other cases of intellectual property like patent law, etc., where the nature of those limited exceptions is usually made in a very limited way. But in copyright, you would see rather a lot of exceptions. But the most important pillar of the copyright system is not just the rights component, and my co-panelist Harini mentioned there is a negative right to exclude others, but look into the remedies. If you go through the remedies part of intellectual property, not just the copyright law, the remedies are injunction in alternative to accounts for profits and damages, which means basically if the right is exclusionary in nature, the remedies ought to be exclusionary in nature, right? However, the law, not just in India, across the jurisdictions and including international conventions, allow the judiciary to carve out and tailor remedies, and in some cases also deny a very strict exclusionary remedy. If that is the case, do we or can we really call the copyright system as a very strong property right system? Perhaps not. However, when judges exercise that freedom of not to, grant injunctions, there must be very strong reasons of why the defendant is allowed to continue infringement. And I'm raising this point primarily because today the contestation in the next few years is going to be around this, particularly these kind of issues, wherein you are not going to face free, fly-by-night operators who are pirators, who are dumping your, copyrighted materials in the, market, but you are going to find sophisticated tech companies who you would be encountering. So when you are faced with sophisticated defendants, do you think really the court is going to give a very simplistic opinion with reference to, yes, copyright is an exclusion right, the remedy should be an injunction? I doubt. And that is where I think my idea that the copyright system has to be strengthened, etc., is fair enough, but it will have to go through rounds and rounds of evaluation, particularly when it comes to how the judiciary is going to behave in the way they do.
Thank you for a really interesting, perspective, and for allowing for a very organic segue into my next question, Yogesh. So, sir, if you're still online, and if you
Yes,
can
I'm
still hear
available.
us clearly, I think, were you able to hear all the other panelists? And if yes, then I'll move on to my next question.
See,
So, sir, my next question is, Yogesh spoke about fair use and fair dealing. And since this is a jubilee, celebration of the publishing industry, so my next question is, in particular on the role of fair use provisions in copyright law. So in particular, sir, can you, address the education exception to Section 52 of the Copyright Act and its effects on the publishing industry? And sir, in your opinion, can this exception be made more balanced to accommodate the rights of the publishing industry as well as the authors, and on the other side, the need of educational institutions and students?
yes, answer is yes, there is a need. I do understand being academician also, and being attached with the academic institution, and now wearing the cap of a registrar of a copyright. There is a need to have the balanced approach here, and when we see that the fair use, what is the fair use? Is it by the individual student? Is it by the individual faculty or institution supplying this material? So this is something which is not the fair one. So individual use, maybe differently it should be treated, and the kind of rights of a publication industry. So this is something which needs the balanced approach, and what is this balanced? I think this needs the discussion and deliberation, and maybe a roundtable on the specifically the provisions related to the publication. We would be happy to host this kind of a discussion in IP office, in Mumbai, in Delhi also, whatever is appropriate to the delegation, and let's discuss, because uh, this is a entirely, the legislative amendment is a long exercise, but we should not wait that this is going to come and now we start. We should start the discussion, deliberation, and then the kind of submissions and thoughtful and carefully drafted provisions may be made as a submission to the government of India. So, and but for students and for academic institutions, specifically the faculty, they should have the exemptions. That's my clear observation here.
Thank you so much, sir, for your input on this question, and I will put the same question to you, Harini.
See, again, so there is no dispute that there has to be an exception to exist, right? All of us understand that. We've all studied, we've at some point of time taken the benefit of this exception, and we are here today, right? But to what extent? I think that's the question. I think that's the question that everyone is at, is with respect to this very, very wide exception. What is, to what extent should this be open? Something that comes to my mind, and I think it's also given as, I think even the Parliamentary Standing Committee had similar observations, and I agree that maybe don't keep everyone under the same, you know, the institutions specifically under the same bucket, maybe split it, right? You want to help students who do not have access to education, and in furtherance to that, the instruction of that, then maybe carve out or keep this as wide to government-owned institutions, and the students can benefit there, right? With respect to private institutions, maybe we can have, like as Sir rightly said, right, having a copyright IROs kind of an organization come up with a bundle of licenses which can enable the university on the whole to be freely using whatever they have access to, right? And students can benefit, teachers can benefit, their research doesn't get stopped, they are freely pursuing the research, publishing their research, which is their core goals as academicians. All of that is not stopped. I think already the systems have it. Like IIT, while I was studying, we had access to Jaster. We had access to all of these, online papers, right? Where we wanted to this. Now, outside I come, I want to do the same level of research. I don't have access to the same set of papers which get published on that. And the quality of them are remarkably different. Now, similarly, today we all have access to OTTs. Right? So you have a login, you enter, you have like so many movies of any language, whatever be or this, given to you under one, in one place. Similarly, when we have this sort of a assortment curated depending upon their needs or whatever the university, depending upon what their fields of education is, what they are interested in, if that can be curated and presented to them, that gives us easy solution for the copyrights to sustain and the academicians to do what they want instead of opening the R52, Section 52 exception to be this wide. Right, so that's maybe a couple of things, and these ideas are not new. These ideas are there. They've been presented, and I think they've been also accepted to an extent. It's a matter of this becoming like a part of our law, and or at least in the form of some guidelines. If this can come out, right, it can help protect copyright owners more, and that brings out the balance between the need of the educational institutions, the fact that we want to educate, not take away that, because that is the goal at the end of the day, but at the same time, the rights owners are also incentivized.
Thank you. Yogesh, what about you?
Yeah, thank you very much. Let's go back and look into the conceptual underpinnings of the fair dealing provisions. The conceptual underpinning is that there are huge transaction costs that could be avoided from having very limited exceptions, in the sense that it does not constitute a direct diminution of the rights of the copyright holder. And that seems to be the, what you call, and it should not conflict with the normal exploitation of the right of the copyright holder. At least the Berne Convention, the TRIPS Agreement have these three-step tests laid down as formulations for how countries could have their fair dealing provisions. Here and there, countries are going to try and test and broaden it as far as possible, as India has done. One of the dilemmas for the publishing industry is it's a publishing industry provides for what is called as a market for education. But the rest of the world doesn't want education to be accepted as a market. And that's where the dilemma for the fair dealing provisions starts, as to why these fair dealing provisions exist the way they do, including decisions of the high courts, which say that any kind of what you call usage with reference to educational exceptions, if it is reasonably connected with education, should be allowed. But then the question that would arise is, why do other forms of alternatives in the copyright system exist, particularly with reference to compulsory licenses, where the compensation must be paid to the copyright holders? If you are articulating a premise that educational exception has to be so broad that it must encompass all kinds of what you call usages that directly would conflict with the normal exploitation, then the existence of compulsory licenses, which is based on the fact that these are granted based on remuneration or compensation to the copyright holder, would simply not have existed in our Copyright Act. And it is very interesting that even in the current disputes that are going on in relation to what you call these shadow libraries or pirated libraries, this kind of points are not being widely discussed as to why legal approaches that are there for access to education. And India fought very hard, as I mentioned, in the 70s in the Berne Convention context. And India was the pioneer and the leader to come out with what is called as the Berne Appendix, which laid down the system for compulsory licenses for reproduction and translation. And it seems that if there is a real concern to be addressed, the real concerns has to be addressed through free uses rather than compensatory uses, which the copyright system does allow. So I think there must be a rethinking around the exact contours of what these limited exceptions are meant to be conceptually, and why the alternatives with reference to compensatory regime, which when your properties are expropriated, you are entitled to have, are not being utilized if the concerns of excess are to be addressed. So not denying that there are concerns of excess, but the fact that why the legal regime is not utilized the way in which it is conceptualized.
So Yogesh, I'll continue this question with you. In your estimation, how can this balance be brought about?
This balance should be brought about by thinking about each of the what you call exceptions individually vis-a-vis the specific nature of rights that are abrogated or diminished. So, and this balance is actually very well stuck in the TRIPS Agreement, and also in the Berne Convention by way of the three-step test, which says the exceptions are to be limited in nature. And by the word limited, or in special cases, they say, these special cases need not mean that there has to be always a public interest, but special cases can be exercised in all cases. But the nature of those special cases must be such that the diminution that happens into the right of each individual, because these are bundle of rights ultimately, right? Copyright is a bundle of rights. You have various kinds of rights that are there. And in each of the category of rights which get affected, you must analyze and find out individually whether they do constitute a normal exploitation. The problem being, in case of educational markets, the market for education itself cannot be completely subsumed in the idea of fair dealing provision. If that is happening, to some extent, if it might happen, due to the exercise of fair dealing provision, then naturally we know that the contours of fair dealing provision have gone far beyond what is conceptualized historically from international agreements and also from our own old practices. So I think that would be a good symposium in itself as to how do we structure them.
Yeah, and this ties it back to Professor Pandit's offer to have a roundtable, because this actually I think is what the publishing industry has been advocating for some time now, and it would I think in the education sector, as you pointed out, it's a big irony that while the publishers are catering to the education sector, it's that very exception that's sort of coming after them and making all of their incentives go away. So I don't think that that's fair. And as Professor Pandit pointed out, it's about time that the industry, along with the policymakers, they sat down and discuss and chart out in details what the contours of this exception should be and how far it should be allowed to go as it pertains to the education sector. So let's come to the issue of collective rights management. And IRRO, as was mentioned just some time ago, is a collective rights management association. So Dr.
Gauri,
Pandit, if you're still...
Gauri,
Yes, sir.
I have to leave.
Okay, sir.
I have one meeting with ministry, so my sorry, my apologies. I have to join there, and this meeting is about to start in a minute. Sorry.
No problem, sir. Thank you so much for joining.
Thank you very much.
If we could
And
have a round of
would
applause.
certainly like to you to give this message to IRRO and its representative that would be happy to have a meeting to discuss the pressing issues which they are facing, and certainly would like to have a periodic roundtables meetings with the IRRO, so that we can better understand each other and try to bring out the solutions which the industry is facing, and the publishing house which they are facing as a challenge. But certainly I would also like to make a submission that though the copyright is a voluntary right, and but it is always worth to have the certificate of a copyright getting published in the books or journals also. This is something which is going to offer the strong protection, and even in case of infringement which is happening, the certificate is going to offer the authenticity of the creative work, innovative work. So I would also like that so many books are getting published, but they are pro bono writing this copyrighted content, but it is worthwhile to have the registration certificate also. Even before publication is always advisable, but even though it is not happening, after publication also they should be getting this, for securing the right as a publisher, as an author of the creative content. Thank you very much.
Thank you so much, sir, for your message to the publishing community. Thank you for your time, sir. So we will proceed with our discussion. I will take this question to, okay, so let's talk about public awareness. Harini, I'll bring this question first to you. So obviously we all know that, there are a lot of people out there, the members of the general public, who many times unfortunately may not be aware of the fact that they're violating IP rights, and particularly copyrights, now that everything is digitally available. So what do you think, what are some of your ideas on what the policy makers could do to raise that awareness, and whether you have any recommendations for the publishing industry to raise that kind of awareness?
As I understand, CPAM is working on awareness sessions, right? But they are targeting, I think, judiciary. There is academic awareness, and there's also awareness for law enforcement officers as 3 primary categories which they are pursuing to bring about awareness, right? Now, other than that, if you see rights owners who, like if you can put them under the broader bucket of like corporates, they are also bringing about awareness amongst the, you know, whoever is their stakeholders, and quite a bit of them, there is continuous sessions of awareness going around there. Now, of course, so to the general public, I think in some form we have to expand this, right? Because I have had cases where in very remote places as brand owners, when we've tried to go ahead and even, you know, try to distinguish whether there is a counterfeited product which is having like a entire label which is copyright protected, right, on the particular product, and people have no clue, right? They themselves, some of them, the person who might be running the operation is very clearly aware what they are doing, but other people don't know, right? And the similar thing, like, so again, to such people, like just as a layman, if I'm going to go and explain what my job is, who I am, what do I explain what an IP council does, right? Which means there is a huge amount of lacuna in understanding what is IP, and a subset of IP being copyrights in the masses. It's the same with business, small business traders, even MSMEs. MSMEs, maybe, yes, they are aware, but they don't go ahead and file as much because of other issues. But the ground reality is people are not aware of the presence of these rights in the first place. And if they are aware, they are interchangeably using, right? You would have very commonly heard someone saying, I've even heard someone saying this is a patent dialogue, right? So we're just interchangeably, people are using the terms of IP. So there is definitely the need to be bringing that to a common man level. And I think, of course, CPAM is, I think, doing it with schools and universities. So students are at least having, this generation which is growing up is having an idea of what these rights are, which I think I studied maybe directly in my third or fourth year of engineering. Is first time I heard about what IP rights are. At least students today have that privilege to know what IP is at a much younger age. Maybe as parents, what we can do is something they are coming up with, right? A small picture, a diagram, you know, a piece of art that the child has like worked on, maybe encourage getting a copyright, right? So it just puts them through that entire process of what it is and brings about awareness. So such small things, if schools encourage that and if parents encourage that, that's kind of awareness happening at one level. Now, to the rest of the people, we have to, again, of course, CPAM has a focus. They are working on bringing awareness to certain section of people first, and then maybe at the next level, go further deep. But I think definitely small business people, traders, definitely need to understand the importance of copyright. And generally, when the collective awareness of this raises, right, I think there's all that consciousness from the kids. I think today people would say that today's kids are more making more sustainable fashion choices, right? They are questioning about the environment. They are making choices which maybe our parents were not making. So if this becomes a part of the psyche, if awareness is risen at that level, so obviously questions on counterfeiting, piracy automatically gets addressed because you are working at a collective level to bring about that change on what IP rights is and what copyrights are and what they can do, why they are necessary. All of these things should get addressed. Yeah.
So Yogesh, what would your recommendations to FIP
awareness?
and IRRO be?
On awareness, please don't do anything on awareness. I'll narrate to you at least what happens in India's premier universities, okay, in terms of how copyright gets infringed. Primarily, India's top universities, okay, I'm not speaking about the tier 2 or tier 3 universities. There is a kind of a very structural barrier in terms of access to finance for, in terms of their library resources, etc. They are very stretched. and they may not be, really subscribing to, prestigious journals, etc. But the top premier institutes do, which makes us, or which should make us think that, oh, they would not be accessing any kind of pirated content, that they can procure through shadow libraries. But that's not true. Students and also academicians often access through shadow libraries because of one primary reason, that is aggregation. The content is aggregated at a specific point, and the search facility available on that shadow library makes it easier for them to access that content and not go back to their remote access on the library and then search on the specific, what you call, JSTORs or Hein Online or Westlaw. And that seems to be one of the major reasons why even in premier universities, not just in India, but anywhere abroad, including the United States, whenever shadow libraries used to exist. Now, of course, those countries have taken measures, including judicial measures, to stop those shadow libraries within their jurisdiction. But when they did exist, they were also seeing this kind of downloads happening. And the primary reason those surveys showed was not because of lack of awareness, but it is because of the lack of aggregated sites that provide for copyright content in a bundle. Why is it that the collective rights management organizations who collect royalties together are able to also license content together by pulling together these resources and having a kind of, you have to do a little bit of tech investment rather than awareness. That's what I meant. So if you do that, then it is quite possible that the licensed content is the one that is accessed, and it should not appear, whoever is deciding a particular judgment one fine day, that, oh my God, India is such an access problem because there are so many number of illegal downloads. It means that really the content is not available. It may be absolutely wrong to construe that data that is shown is actually a representation of the problem of access. Because I can tell you, in top tier institutes, the access problem is way, way different from the other kind of institutes. But if it is happening at top institutes, then the real question is aggregation. Then the problem is, why is it that in the music industry and in other industries, content aggregators have developed and they have largely facilitated legal access to music? The iTunes of the world, or whatever other platforms of the world. Why have those platforms not emerged in the publishing industry, where content can be aggregated and aggregated content can be legally accessed? If that can be done, I think the problem of awareness is only then a secondary kind of a problem, second order problem, not a first order problem. Thank you.
Yeah, I think you might be right, because, if anybody studied even basic human psychology, in the pyramid of needs, if something is convenient, the morality, the moral aspects and the legal aspects are secondary. So that's probably some food for thought for the publishing industry. Are shadow libraries legal in India? Is there any?
That's why the litigation is going on currently.
Oh, okay, okay.
The Sahib Libgen litigation.
I see, right, okay. That they pertain to shadow libraries.
They call it shadow libraries, but essentially what it means is basically 80 million downloaded articles from different universities in the world is uploaded on one single website.
And right now these are legally accessible in India.
Of course, there is a temporary ban on these, but you can have mirror sites that can be accessed, and I can see it day on and day out that these mirror sites are regularly accessed by students, not for lack of awareness. Not for lack of awareness, but because it is easy to access it at one place. And mind you, we have subscribed to the best of journals, but all those best of journals are also from the licensor's perspective, from the copyright holder's perspective. You might just think, what is the big problem? You have already licensed to the libraries anyway. Rather than from the libraries, they are accessing content on shadow libraries. But it also means that you are part and parcel of legitimizing the shadow libraries.
That's food for thought. So let's go on to the last question. And this is, we will not delve too much into it because this forms the meat of the following session, which is on artificial intelligence. But since we're talking about, aggregating content online, shadow libraries, and basically all things digital, I think it seems only fitting that we end with this last question, which is around artificial intelligence, which is like the buzzword these days. I mean, even if you wanted to avoid it, I don't think you would be able to. So let's start with you, Harini. So generative AI is, evolving at the speed of light, and it's becoming obviously more sophisticated. So what do you think, I mean, and to the point where it's mirroring human creativity, after some time it'll be very difficult to make out on the news or on video if somebody appearing on it is, a digital version of a real human being or not. And in some cases it's slowly becoming a reality. So how do you think the copyright laws need to evolve to protect the rights of human creators?
We should definitely have certain AI specific provisions, right? In our entire laws, all the other laws as well, patents and trademarks also. If I'm giving, I think as a exercise last month or something, we worked, like one of my colleagues, by giving inputs, we came up with certain images, right, which could directly be used as trademarks and logos as a device mark. So question, what comes to me is, I've also seen that when we've asked for certain information, the information that comes out of the current versions that are openly available is not completely consumable. It's not, in certain places it's incorrect or it's not updated, all of these things. But assuming that obviously in the newer versions all of those issues are not going to be there, then we definitely have to understand, we definitely have to see how we are going to be able to overcome. It's not about overcoming, but how we are prepared, right, to be able to address issues which come out of AI. Now, one thing that comes to my mind is attribution, right? If a news anchor is generated as an AI image and she is coming on my TV screen, maybe I would want to know that it is an AI generated image as against a human being. I would like to know where there is human actual intervention and creativity. I think the Grammys, if I'm not wrong, have told that anything that is coming out of an AI generated music will not be eligible for awards, right? Only something of human creativity, which is coming out of human creativity, is even eligible to get nominated, etc. So I think I go in the lines of that. Okay, I want to know what is coming out of that, what is not coming out of that. We definitely need to have laws which are specific, which will definitely address the issues in the different segments and maybe make relevant changes in the existing legislations, or maybe even bring about a separate legislation if need be. I think it's a separate, I think in the following panel, maybe they're going to go into the depths of it and understand, because from a patent perspective, there are different issues. From a copyright perspective, there are issues. Trademarks, maybe not as far as the marks, but these two segments definitely require deliberation on how the software, the AI is developing, and what we need to take care to definitely leverage it, because that's where we are being catapulted into the next, that's where it's all going to lie. Maybe it's going to even help us in R&D, like furthering where our economy is going to go as well. So how we leverage it, but also protect the rights of the owners, this definitely needs further discussions and according amendments, being brought about.
Yogesh, AI, is it good?
Yeah,
is it bad?
Yeah, I would have equally loved to be in the next session also, because that is emerging as a big issue. And if I may also draw Ankit's attention on the AI question, because that's your session, and perhaps you would like to answer this. There are two aspects in AI from at least my readings. One is the creativity issue with reference to the creator being the AI, and how do you ascribe any kind of authorship and ownership to it. more so authorship. And the second question is the liability issue. If AI is itself creating content based on scraping of data, particularly including your publications, which are digitized and put up online, then there are different set of liability issues that emerge. On the creativity issue, I think most jurisdictions are saying that okay, the human author is the one that historically copyright system has created, but has conferred to. But I have a very serious doubt, and perhaps in the next session this should be addressed. If you may know, whoever has done a little bit deep dive into our copyright system, software is protected both in object code and source code. Okay, and source code is the one that is written by the coder. That is the creator, who is the human author. But the object code is not written by the human. Object code is translated from the source code by using what you call software called compiler. There is absolutely zero human intervention when it comes to the creation of the object code. And yet, for the last 2-3 decades, copyright system has protected the object code without ascribing any questions or without asking any questions with reference to the question of whether the authorship is human or machine generated. And if that be the case, are we going to have significantly different issues in the context of lack of human intervention in AI-based creativity? I asked this question recently at a WIPO forum, and looked like nobody had an answer to this question. And most probably Ankit can take up this question on, I hope the question is clear, Ankit? Yeah, if the object code exists and it is protected under copyright law, what is the problem in protecting any kind of AI generated work? Primarily because in object code also there is a software that translates the object code, source code into object code using a compiler. That's called as a compiler. So, I mean, there can be technical nuances to it, but I'll leave that question there. But the liability issue is what can be interesting to publishers, because I'm sure that publishers have not reached a stage where they are using AI technology for creative purposes, in the sense that you yourself are AI companies. Then you would have your own conflicting interest. Kya karna hai copyright system ka? Will you be regarded as an AI company, or would you be regarded as a publishing company? And I'm sure that is never going to happen. Both. Okay, that would be very interesting. So then, academically at least, I enjoy these kind of things, because then you're saying that you have both stakes. Stakes as an AI creator and stakes as an AI, stakes in terms of publisher, in terms of liability of AI for copying your or infringing your copyright. Of course, you can always take your copyright, but you will be infringing on your others, right? On your federation's members. So now, if that be the situation, because of scraping, etc., the problem recently, Google seems to say, or at least the internet companies seems to say, AI-based companies seems to say, that the option should be the opt-out clause, which means basically publishers should say that they want to opt out of these text data mining and scraping things. The other side is, problem that seems to me is, you may want to opt out and you may also opt out, but what about the 80 million papers that are there illegally stored on all these websites, where the rights management information has been removed, or you can't technically find out whether the copy was under a license, where does it come from? Sometimes you may, sometimes if the right management information is removed, can those AI companies, including your new companies, will you be able to identify whom does this work belong to? Because you are scraping the data from the internet anyway. And it is going to be a mess. And I think we need to wait for the next session to delve into this. Thank you.
Thank you. Any questions from the audience?
Yeah, regarding this Indian Reprographic Rights as organization, even Professor Unnat is also talking about it. If any particular work is now submitted for copyright protection, they say even a small change in that work would ruin the original copyright applied for. Is that true? Suppose, say, a novel is presented for copyright protection to IRRO, right? Suppose any change subsequently is made in the work, will that affect?
I think without the author's permission, that is not, there's mutilation of the actual material. In my opinion, I think it is a mutilation of that and it is not allowed without the permission of the author.
Even if the author
Author is agreeing to then definitely.
Then, it's like a derivative right. It's like an adaptation.
Derivative is
right?
altogether different. Someone else is doing and taking the
Yeah,
rights
but
from
he's
you.
saying without permission or with permission?
No, with the permission. With the author himself, suppose he wants to make a change, the author wants to make subsequent changes in that, does he need to again resubmit for copyright protection or what?
As a derivative, no. For derivative works, you don't need to because you have
Derivatives are not
any other copyright practitioner. Ankit, would you want to answer this question? Whether do you file applications for derivative works, with the Copyright Office for every little change that you make in your book or if the work constitutes something more than a derivative in itself, which is original in itself, then definitely you will have to file different applications. Yeah.
Thank you, Yogesh, though my session is the next one, but I'll take the liberty of jumping in. So, sir, to your question as to derivative works, now the question regarding registrability, you see, we have to divorce the concept of registrability and enforceability. Registration, as Professor Pandit mentioned, is really an optional right. Not just in India, but broadly, copyright automatically vests the moment you create something. Only to improve, let's say, the dynamics or the possibilities or the prospects of enforceability, having a registration certificate gives a very important strategic tool in your hand. Because there is a small, often overlooked provision in the Copyright Act which says that registration of the copyright is prima facie proof of its validity. Validity of the ownership, validity as to what is contained in the work. And that tool often is the answer or the thin line between you getting relief from the court, ideally as we hope for in the very first day against people who are infringing or not. So the moment you create something, now when we jump to the topic of derivatives, if the question is that somebody is, for instance, copied your primary work and created a derivative out of it, a derivative work is considered broadly as an infringing work if appropriate consents have not been taken from the original copyright owner. If the derivative work is of such a nature that it is substantially different or even different to the extent that it can stand on its own two legs, it may be subject matter of registration, or at least aspects that are different from the original may be subject matters of registration. Now, it's such an abstract concept, but to take an example, Omkara movie based on Othello, so like there wasn't any, everybody knows in this room, it's not even the right audience to remind everyone that there's no copyright in an idea, right? But assuming there was copyright in Othello, and copyright subsisted when Omkara was made, and assuming some of the flow of events or dialogues, etc., were copied from Othello or others, let's say any XYZ book that any of your publishing houses may have published, and a movie is made on that. Now, a movie is a derivative work, and to that extent, you would frequently read news of the publishers approaching a court and saying, movie is a derivative work when I owned the copyright over the plot, the story, the novel. How could somebody else go and make a movie without my consent? And injunctions are granted frequently on this account. But to the extent that the movie is a creative work by itself, there may be songs, there may be dialogues, there may be other aspects of the movie which are visual effects, etc., which provide it legs of its own to stand. And those aspects of the movie, to that extent, are subject matter of separate protection. So I'm not sure if I addressed your question appropriately, but this is basically what comes to my mind. Thank you. Thank you.
I think there's another question in the back.
Hi. So my question is, being a small Indian publisher, how do I protect myself from the universities, as you are mentioning that sometimes they, like the copyright is violated. And the other part is, how do I protect myself when it comes to copyright violation through Amazon and Flipkart and from shadow publishers? Like you are mentioning shadow libraries, but we all agree that there are so many shadow publishers these days, and how to protect ourselves from them. Are there any provisions like being a small Indian publisher when the law and everything is very lengthy and like the cases take such a long time? So how can we like safeguard ourselves?
Okay. Well, if you are a small publisher, the copyright law in that sense is a little unjust because you need some money to fight litigation. Okay. But having said that, let me tell you the alternative. The alternative is join the IRRO and let them fight your battles. Okay, if there are really big battles. The small battles you want to fight, usually, because you mentioned shadow publishers, these are fly-by-night operators, I assume. These are not established publishing houses. At least those who are, at least not the people who are present here.
They are cropping like in thousands these days, and not just from India, but from outside India.
Absolutely, but I'm sure that these are not people who are here, right? Right? So it means it is a possibility that these are publishers who are fly-by-night operators. Like these really do not want to have a long standing in the business. There are reputational impacts otherwise. I don't think anybody would want to violate anybody else's copyright in a book being a publishing house. So fly-by-night operators, you can always get an ex parte. Please contact Ankit. Ankit is going to help you in getting those orders. And ex parte orders in case of fly-by-night operators where there is a very, good case to make, because the piracy is a direct infringement, okay? And in that sense, it would be easy to get ex partes, and the litigation in that sense would end with the ex parte itself, and it would never go to trial because the party would just have to shut it down.
So, in the realm of trademarks and basically I would say, I think Ankit, I'm probably thinking of the concept of dynamic injunctions. So that's an idea that maybe could be applied to the copyright scenario and the thousands of these shadow publishers that you were referring to, where maybe you get like a blanket order and that it sort of keeps on repeating itself. And I mean, it's a different matter how you would enforce it. But certainly that's something that our courts are very well equipped to handle. So maybe it's another project for the IRRO and the FIP. So lots of action points that have emerged for the two organizations. And I'm sure that they'll keep you busy if you're not already busy enough. But thank you so much. I think we're at the top of our allotted time. And this was a very interesting discussion. If there are any other questions, then Harini and Yogesh are here for some time. And I am here as well, and it'll be great to interact with you after the sessions. Thank you so much.
Thank you.
May I request you all to please kindly stay back just for a moment more. We would like to express our thanks and gratitude to the esteemed speakers as well as the moderator, and to do the honors of presenting a memento as a token of our appreciation and thanks, may I invite on stage Shri Pranab Gupta. He is the conference director as well as the Secretary General for the Indian Reprographic Rights Organization. We thank Ms. Gauri Kumar. This is a certificate as well as the book, 75 Years of Book Publishing in India, which is being presented to all the esteemed speakers. We thank Dr. Yogesh Pai. And we thank Ms. Harini Niveda. Thank you. With that, we conclude this session, which was entitled Significance of Copyright and Intellectual Property on Publishing.